talk about the latest 2025 rulings on the Corporate Transparency Act Beneficial Ownership Information Report. Now, imagine this. You're a small business owner, busy balancing payroll, taxes, and day-to-day operations when suddenly you're hit with a letter demanding $10,000 in fines. Oh, by the way, it's $591 per day until you fix the issue. Welcome to the world of the Corporate Transparency Act, or CTA. It's a law that has many people confused and even more worried. And today I'm here to demystify the CTA and give you an essential update for 2025. We'll cover what's happening in the courts, what you should be doing right now, and why this law exists in the first place. And by the end, you'll have clarity to protect yourself and your business. And hey, if you find this valuable, don't forget to like, subscribe, and share it. So let's get into it. So what exactly is the Corporate Transparency Act and why does it matter so much? The CTA is a federal law that requires businesses to disclose their beneficial ownership information to the Financial Crimes Enforcement Network, or FinCEN. And this law aims to combat the serious issues like money laundering, terrorism financing, and tax evasion. Sounds noble, right? But for many small business owners, it feels like yet another bureaucratic headache. And I agree, I don't like it. I think it's just a bunch of paperwork and busy work that doesn't need to be done because the banks already have the information. So it's just redundancy, my opinion. Nonetheless, to understand the significance of the CTA, let's take a quick journey through the timeline and legal battles. And along the way, I'll share real life stories, examples, and a few surprising statistics to keep things engaging. Now, the CTA officially became law on January 1st, 2021. At that time, the world was dealing with a global pandemic, and this law quietly made its way into the books. Now, fast forward to today, and we're still grappling with the implications. So here's the timeline of the key events. January 1st, 2021, the Corporate Transparency Act is enacted. December 3rd, 2024, a nationwide injunction is issued by the Fifth Circuit District Court in Texas in the case of Texas Top Cop Shop and the National Federation of Independent Businesses. On December 23rd, 2024, the injunction is stayed, meaning the CTA's requirements are temporarily back in effect. And then on December 26, 2024, the stay is vacated, allowing the injunction to remain in place. So currently, the case is pending before the Supreme Court, and Justice Alito is the one deciding whether the court will hear it. The oral arguments are scheduled for March 25th, 2025. Now, while the injunction remains in place, there is no legal requirement to file your beneficial ownership information for now. But sometimes the best question isn't, do I have to or not have to? The best question is, should I or should I not? So that's the question we really want to get to. So let's talk about why this matters. If the injunction is lifted, businesses that fail to comply with the CTA could face several penalties, including $10,000 in fines, $591 in daily penalties, and up to 2 years in prison for willful noncompliance. So here's a real-world example. A small coffee shop owner in Ohio formed the LLC back in 2018, and they had no idea they were required to file under the CTA. Now, with the injunction in place, they're temporarily off the hook. That's temporarily, but the injunction, if lifted, they could face fines that would devastate their business. So the stakes couldn't be higher for small businesses like this one. Okay, legal battles and where we stand. Now, the CTA has faced significant legal challenges, and here's some of the key cases. Winkles versus Yellen in the Northern District of Alabama. Now, this case argued that Congress overstepped its authority over or under the Commerce Clause. Now, while the court ruled in favor of the CTA's constitutionality, it granted an injunction for the plaintiffs, but these plaintiffs only in this case. Then there's Firestone versus Yellen, Michigan. This case also challenged the law's constitutionality, but failed to secure a nationwide injunction. Community Association versus Yellen is another case. This case questioned whether the CTA infringes on states' rights, but like the others, it did not result in a nationwide injunction. Now, interestingly, only one court, the Fifth Circuit, granted a nationwide injunction, and the CTA, if it were a clear-cut constitutional law, why didn't more courts block it? So this has left legal experts and business owners wondering about the future of the law. So the question is, should I file anyway, like we asked? Now, for the million-dollar question is this: should you file your beneficial ownership information even though there's no legal requirement right now? And my thoughts or it depends on your risk tolerance. So let's break that down. For the risk averse, if you're someone who likes to sleep easy at night, go ahead and file. The government already collects your information through tax filings and bank records. I mean, they already need the information, which is another emphasis in my mind why it's stupid to have to do it again because it's redundant. But nonetheless, that is the law. We got to do it. So filing with FinCEN won't reveal anything new. So, some people just like to stick their heels in and say, I don't want to do it. It's government invasion. Well, unfortunately, they already know. The banks already know. The government already knows. It's already filed in other places. For the risk takers, on the other hand, if you're willing to gamble that the injunction will hold, you can wait. But remember, if the injunction is lifted, you'll need to act quickly to avoid penalties. And that's the reason why I would recommend that you subscribe to the Business Guy channel, because I'm going to let you know if I can. You don't rely on me. You got to rely on your attorney or whoever you rely on, or other sources. But my commitment is to, when this law changes, I'm planning on making another video. So subscribing to the YouTube, my YouTube channel, or this channel, wherever you're seeing it, could save you 10 grand and $591 a day. So if you've never subscribed before, now might be a good chance, because I'm going to let you know when things change. A landscaping company in Texas is another story I want to tell you. Waited until the last minute to file in 2024. When the injunction came down, they thought they were off the hook, but when the stay was lifted briefly, they had 3 weeks to scramble and file. So don't let that be you. You don't want to be under that pressure. That's why I get to the airport early. Now, a lot of people view the CTA as just another example of government overreach, and they argue that the government already knows too much information about us. So you probably know that banks are required to report transactions of over $10,000, like in cash, or that your tax returns include detailed information about your income and expenses. You know that already. On the other hand, supporters of the CTA argue that it's necessary as a tool to fight crime. So an estimated, they say, $300 billion is laundered annually in the U.S., and the anonymous shell companies are often used to hide illicit funds. To prevent these illicit funds from circulating through the system, by requiring businesses to disclose their ownership, the CTA aims to close this loophole. And I would guess probably 99.9% of us aren't laundering money. So the 0.1% of whatever the number is that are, fortunately, like 1,000 people have to report for every one that's doing shenanigans, I would guess. So to put this in perspective, imagine a scenario where a drug cartel was using shell companies to funnel money through real estate investments. There you go. Without transparency laws like the CTA, catching these activities becomes nearly impossible, because with the way it is now, there's a way to use that people don't even know who the owners of the company are. And so they can take, millions of dollars, put in this company, buy real estate. Who knows who owns the company? So the drug cartels through these LLCs that are private own, say, the skyscraper, or whatever it is. I'm not saying that I like it. I'm just explaining what the supporters of this law say. So what happens next? Looking ahead, here's what we can expect. On March 25th, oral arguments in the Supreme Court. Late 2025, a potential decision from the Supreme Court. So that's late 2025. Legislative efforts. Congress nearly repealed the CTA in 2024 during budget negotiations. Well, repeal is still possible. It's unlikely in the near term. So if the injunction is lifted, businesses will likely have a short window to comply. Now, in previous cases, courts have given as little as 3 weeks for businesses to file. So are you prepared to act that quickly? Let's say you don't find out about it, that the injunction has been lifted. Are you, you don't want to get caught. So here's a historical comparison. When similar laws were enacted in the past, like the Foreign Account Tax Compliance Act, or FATCA, compliance deadlines caught many off guard. So businesses scrambled to avoid the penalties, often at great expense. So the Corporate Transparency Act is a complex, evolving issue. So whether you're a small business owner or a corporate executive, staying informed is really your best defense. So don't wait until it's too late. If you're still unsure about what to do, consult a professional. If you found this video helpful, please subscribe, and I hope to see you again, and share it with others to help them out. So I'll keep you updated as to new developments as they unfold. So stay tuned. Until next time, protect your assets and your peace of mind. Okay, Now, if you're still with me, let's dive in a bit deeper to the intricacies of how the CTA impacts different business structures. So, for instance, sole proprietors operating under a DBA might not feel the heat as much as LLC owners of corporations. However, partnerships and trusts, especially those with multiple layers of ownership, they can find themselves in murky waters quickly. So consider this example. A small real estate firm in California operates as an LLC, but it has 3 silent investors, one of whom resides overseas. Now, under the CTA, disclosing all beneficial owners becomes a bureaucratic puzzle. Each owner's data, from their social security numbers to their exact ownership percentages, must be reported accurately. And if you get it wrong, well, that's where the penalties start to snowball. So let's not forget about the human element. People make mistakes. I mean, even large corporations with dedicated legal teams have found themselves in hot water due to clerical errors. Now, the CTA's stringent requirements mean that a typo could cost you thousands. So this is why I always say, if in doubt, consult an expert. And for those who are thinking, well, I'll just dissolve my LLC and start over. Well, think again. The government tracks these things. Dissolving an entity doesn't erase your obligation to report for the years that it did exist. As we move further into 2025, the landscape of business compliance is becoming more interconnected. With technology like blockchain and AI, governments are gaining unprecedented capabilities to monitor financial activities. Well, this may seem like a dystopian scenario. It's the reality we're headed toward. I mean, for example, consider how blockchain technology could one day be used to create a public ledger of beneficial ownership. So this could make compliance instantaneous, but also raise significant privacy concerns. So the question is, are we really ready for that level of transparency? So finally, let's consider the potential global impact. The US isn't the only country implementing transparency laws. The European Union's Anti-Money Laundering Directive, or AMLD, has similar requirements, and countries like Canada and Australia are exploring their own version. So this means that businesses with international operations may face multiple layers of compliance. So where does this leave you? The best option I can give is to stay proactive. Don't wait for the courts or Congress to decide your fate. So my thoughts are to take steps now to ensure your business is ready for whatever comes next. Go ahead and subscribe if you haven't already. We'll see you in the next video. This is the Business Guy. I'll keep you updated.